Madison, Madison, take your medicine. Damn, you in worse shape than the national debt is in. Sitting there useless as two shits.
Welcome back, folks. In our first video about Madison's L's, the losses that he suffered in the convention, we saw from those convention debates that they reveal something interesting about his opponents and their desires. The people who opposed Madison's negative wanted to preserve the power of their states, and they did so by replacing that negative with a very weak form of judicial review. They didn't really want any more federal power over what they thought were the sovereign powers of their states. So similarly, the opponents of Madison's Council of Revision acted to strictly delimit the role of federal judges. They wanted to limit judges to the enforcement of the enumerated powers of the Constitution and of the boundaries created by separation of powers. Really only to do two things, that is. Now, this was almost the same coalition that defeated the negative. It was a coalition that was afraid of judicial overreach, and it really succeeded in severely curtailing the federal judicial power. Madison's fear, on the other hand, was about first the states, but then also about the overreach of the federal legislative, not judicial power. We saw that in our outline in issues 1A and C from before. And Madison's answer was to combine the executive and the judicial in a council of revision and grant them the power to oppose the legislature in some ways. So, for instance, Madison argued on July 21st in the convention that he wanted to secure what he called the judiciary's, quote, valuable assistance in preserving a consistency, conciseness, perspicuity, and technical propriety in the laws, qualities peculiarly necessary, and yet shamefully wanting in our Republican codes. We could think here that he was referring to national laws, but perhaps also to state laws, our Republican codes. But the opponents of the council had two objections to Madison's proposal, and we're going to call these the policy objection and the bias objection. Both of these objections were about rejecting a prior role for judges in shaping the law. But what they did then was they explicitly accepted a subsequent role for judges, subsequent judicial review, on very narrow issues of constitutionality. Now, Elbridge Gerry expressed the first of these objections on June 4th when he objected to the participation of judges in the Council of Revision because it, he said, was, quote, quite foreign from the nature of the office to make them judges of the policy of public measures. Even though he then went on to approve of judges, quote, setting aside laws as being against the Constitution. So this is the policy objection, and we can define that word policy here as meaning, let's say, wise statesmanship, but also perhaps intelligent democratic politics. Or, in other words, something was said to be, quote, politic if it was well thought out for the state or the country in question, and also perhaps if it was a good move in a political competition, that it was appealing to a democratic people. So judges, Gerry was saying, should stay out of policy. Rufus King then expressed the second of these objections in the very same debate on June 4th, arguing that judges, quote, will no doubt stop the operation of such laws as shall appear repugnant to the Constitution, but he says they ought to review the law, quote, free from the bias of having participated in its formation. So judges should not be biased for or against the laws that they apply. Now, after these speeches by Gerry and King on June 4th, the states voted 8-2 to replace the council with a unilateral executive veto. And that veto, of course, came with a legislative override provision. Now, these are provisions that we're going to look at next week in the Supreme Court case INS versus Chadha. We'll get a much better understanding of them at that time, but it's important to be able to connect this lecture to that later lecture to see what it is that the convention was explicitly choosing when it chose the executive veto over the Council of Revision. Because the upshot was that the legislature and executive were made to participate in making the laws. The executive with the veto, the legislative with the override provision, This forced them to share power, as it were, to cooperate. But the judiciary was sidelined. It was given the power only to adjudicate and to interpret laws. But as we can already see, this subsequent review power was really intended to give them only a weakened version of Madison's very strong proposal that would have allowed prior roles for the judges in reviewing the policy of a law. But Madison didn't give up. He asked his friend, James Wilson, to try again on July 24th. And Wilson steps out, arguing that there may be many injustices that would be done by a law which would nevertheless not give a judge cause to refuse them enforcement because they were strictly unconstitutional. Wilson says this. He says, quote, "Laws may be unjust, may be unwise, may be dangerous, may be destructive, and yet may not be so unconstitutional as to justify the judges in refusing to give them effect. Let them have a share in the revisionary power," or in other words, let the judges be part of the Council of Revision, "and they will have an opportunity for taking notice of the character of these laws and of counteracting, by the weight of their opinions, the improper views of the legislature." So for Wilson, this revisionary power was meant to halt unjust laws, not simply unconstitutional ones. So we can think here of the same distinction that we saw Hamilton make in Federalist 78. Wilson is saying here that a law is only unconstitutional if it conflicts with something like an express provision of the Constitution. That was Hamilton's first argument. But not if it conflicts with individual rights per se. That was Hamilton's second argument. So the constitutionality of a law is a different thing entirely than its justice or its political wisdom, for that matter. Or, in terms of the outline that we were using earlier, issues number 1A and B are very different than issue number 1C, the violation of individual rights. Wilson argues that judges possess peculiar insight into all of these issues, which you might want to compare to Hamilton's statements about the ability of judges in Federalist 78. But the opponents of the council deny that this is true of judges. Well, they recognize that the judges will be empowered with judicial review, but they insist that these judges are not empowered to negate laws based on injustice, the violation of rights, in other words. Elbridge Gerry, in particular, argued on July 21st that the proposal for the council, quote, was making statesmen of the judges and setting them up as the guardians of the rights of the people. We should rely, instead, on the representatives of the people as the guardians of their rights and interests. So something you might think is good, setting up judges as guardians of the rights of the people, he said, was a flaw in Wilson's proposal, a flaw in the Council of Revision. So the opponents of the council recognized the distinction between the constitutionality of a law and its policy, or in other words, its appropriateness, its protection of rights, but they explicitly rejected any role for the judges in determining the latter of these things. Luther Martin, for instance, argues on July 21st that, quote, "A knowledge of mankind and of legislative affairs cannot be presumed to belong in a higher degree to the judges than to the legislature. And as to the constitutionality of laws, that point will come before the judges in their proper official character." So think there about how he's downplaying the abilities that judges might have as compared to the way that Hamilton and also Marshall played up the abilities that judges have, their reason, etc. Now, George Mason, a proponent of Madison's counsel, then implored its opponents not to sort of eviscerate the judicial check on the injustice of laws. He warned them that subsequent judicial review only would actually give judges a check on laws, he said, quote, "in one case only." Here's a quote. "They could declare an unconstitutional law void, but with regard to every law, however unjust, oppressive, or pernicious, which did not come plainly under this description of unconstitutionality, they would be under the necessity as judges to give it free course. But Mason argued this to no avail. He wanted to warn that unjust laws would still be put into effect by the judges, and it seems that the convention accepted this. It was a feature of the Constitution, not a bug, that federal judges were limited in this way. But Madison never gave up on the Council of Revision. He thought it was still necessary because judges ought not to be given any power to judge the constitutionality of a law subsequent to its passage. The only safe course, he thought, was to allow them to speak from their experience on the issue before a law was even passed. In a letter written after the convention, Madison made this familiar distinction between judging a law on the basis of its policy and its constitutionality, and he opposed giving any final or subsequent say to judges on either of these questions. He wrote that granting judges such a power, especially if they weren't subject to override in their exercise of that power, made, he said, quote, made the Judiciary Department paramount in fact to the legislature, which was never intended and can never be proper. So it's clear that Madison was still upset about what had happened in the convention, but he ended up equally upset by the efforts of folks like Marshall to claim for judges an expansive power of subsequent judicial review. That, too, he thought, was a bad thing. Madison continued to believe that the Council of Revision would have been a better idea, believed this really for most of his life, because he thought that judges should be involved in deciding the injustice of laws, but only before a law was made, and only if their decision could be overridden by the legislature, as it could be in the Council of Revision proposal. Judges, he said, were not to be supreme, final, paramount, like some have suggested that they've become in the past 200 plus years of judicial review. Ironically, though, in order to solve this problem that Madison saw in the Constitution that he got in the convention in 1787, the problem being that judges couldn't act as a check protecting rights, he eventually decided it was necessary to further empower federal judges, to give them a Bill of Rights so that they could use the power of judicial review to do what he thought really the Council of Revision should have been doing before a law was even enacted. The convention had botched up his excellent institutions, his proposals in the Virginia Plan, and it left judges in a very weak position to judge laws only after they had passed. But Madison thought that perhaps a Bill of Rights would give them more strength. So in his speech before the House of Representatives introducing the Bill of Rights on June 8, 1789, he says this, quote, if they are incorporated into the Constitution, independent tribunals of justice will consider themselves in a peculiar manner the guardians of those rights. They will be an impenetrable bulwark against every assumption of power in the legislative or the executive. They, the judges, will be naturally led to resist every encroachment upon rights expressly stipulated for in the Constitution by this Declaration of Rights, the Bill of Rights. So this clearly shows that Madison anticipates the Bill of Rights being judicially reviewable. In one sense, what he's saying in the first part of this quote is that passing a Bill of Rights will actually put back into the Constitution the powers of the Council of Revision that had been stripped out by the Convention, the power to protect individual rights, or at least protect them against federal encroachment. But Madison never gave up on the negative either. In his letter to Jefferson on October 24, 1787, that is, after the Constitutional Convention is over, he continues to argue really strongly that the negative is still necessary. He wants it back into the document. He says, for one thing, that it will, quote, prevent encroachments on the general authority, something that he thinks judges are not well equipped to do. That is, protect the federal government from the powers of the state governments. So Madison saw pretty clearly what had happened in the convention. As I put it here, he suffered some major L's. There's no doubt that the framers consciously chose judicial review, but they chose it as a very weak and limited alternative to Madison's very strong institutions meant to protect individual rights and the integrity of governmental structures themselves. So we're going to come back next week, and we're going to look at how modern day courts have actually thought about some Madisonian institutions. We're going to look at Madison's theory of institutional design in his Federalist Papers, and then look at Supreme Court cases that actually reference Madison's theory of institutional design to see, well, what's the state of the Constitution as Madison envisioned it here in the early 2000s. I look forward to talking to you then. Bye now.